So for cannot get in today, go back and watch it, but hopefully that will resolve itself. Maybe everybody trying to get in at one time. As Darkenia said, my name is Dina Hardwick. I'm with Texas RioGrande Legal Aid. I started off with legal aid after Hurricane Harvey. I was in private practice for many years, and I had done nonprofit work, state and government. I've always had a passion for public interest work, so I grew up on the Texas Gulf Coast, came in, devastated us, probably my office, my house, my parents' home, you know, so many people in our community. So I had a friend that I worked with Texas RioGrande Legal Aid, and she said, would you consider taking a few cases under private attorney involvement contract work to help us with some of the overflow cases? I said, absolutely. And then as the station became apparent, you know, much work to be done that I eventually ended up coming on with them full-time over 2 years ago. And as Darkenia said, this is really, it's going to be a long-term process, almost 2.5 years out from Harvey, and we still are doing intake on Harvey cases. So go ahead and put my PowerPoint, but if you're just joining us, to mute your phone, background noise, because I'd like to leave it unmuted so people can ask questions, but if we keep in the background noise, I'll have to mute everybody. All right. Go ahead and mute all. I don't like muting all. Can you hear me okay? All right. Fema appeals. Hold on one second, y'all. I'm going to go, y'all, I'm going to go ahead and unmute everybody because I need to know that y'all can see things and hear things. If everybody will please just mute their phones. Can reduce some of that back noise. We'll go ahead and get started. All right, if not on mute, please be on mute. So I'm going to start off with Fema appeals. If y'all could please, I know we're going to get there. I know it's kind of hectic because people are still coming in, but I want to be able to hear back and forth with everybody. Right now, disaster recovery centers open. Mute all. Sorry, y'all. Sorry, mute everybody. All right, again, I muted everybody again. If you can't hear me, please send me an email or so I'll know that you can hear me. Fema appeals. Y'all have disaster recovery centers open currently. People that are already in this process. So my next portion of this is going to be long-term, mid-term, short-term legal needs. But right now, your clients and your disaster survivors are in the DCs. They're looking for immediate assistance. So that's why I'm going to go ahead and start with this. Money that they receive to get started to help them, either get them in a motel, a hotel, some temporary rental, but it's going to get them in the first step of moving forward in recovery. So that's why we're going to go ahead and start with this. your survivors are already in inspections to their homes and already, I am sure, receiving either denial letters or they're receiving awards. They're going to be insufficient. Experience, we found that FEMA appeals are the #1 post-disaster legal need, and that process will last anywhere from 6 to 8 months. It could go as long as 18 months, and then other issues will come up for your survivors. Some of your survivors will have potentially 6 to 8 other legal issues going on at the same time. So if you are not able to appeal, or sometimes the clients or the survivor will have already started a FEMA appeal on their own, and then they might come to you after. But FEMA appeals are so important because as you have private donor money coming into the state, you know, people are very, very generous after a disaster. In order for your clients to eventually be able to tap into that private money once all the government money is gone, look to your clients and say, did you apply for FEMA? Did you exhaust the appeal process? Did you apply for an SBA loan? They're going to know that your clients through that process. So FEMA is very, very, very important, and applying for those SBA disaster loans is very, very important. But you know, if we don't get enough repair money, one of the big reasons why we're going to appeal these cases and attempt to get them more money, less money, they're going to go out there and hire some contractor that's not a very good job on their home or is going to make matters worse, and then you're going to be looking at some consumer issues that we'll talk about a little later on as we go. So if you're helping a disaster survivor with FEMA appeal or any kind of matters related to FEMA right now with the individual household program, this document, it's a PDF, it is in our materials, but we put it out on the disaster team at Texas RioGrande Legal Aid. If you help anybody with a FEMA matter, you need to print this and refer to it. It will have something in there for helping your client, what you can ask for assistance for, what you cannot ask for assistance for, and just kind of helping clients through the process to understand what FEMA is and what FEMA is not. So I urge everybody to visit that site, look at materials, and print it out so that you understand. If it's not helping a survivor now, perhaps some of you, like some of us, are actual disaster survivors. All right.
I have it on my computer if you want to come and watch it. Okay.
Guys, if I could mute the portion of FEMA FEMA that we're talking about right now. We can hear a little bit of background noise. If everybody just make sure that they mute. Anybody? We'll just have you all work together and cooperate. Put it on, we'll be good. Okay. Better? All right. I'm getting there that some of the background noise is. I don't hear any background noise now. Okay, so FEMA Individuals House Program. So this is the program right now that your survivors are in those disaster recovery centers. This is what they're applying for. They're looking for housing assistance, roof, walls, windows, doors. Maybe some of them their entire house destroyed, and then they're also looking at other needs assistance, anything that doesn't have to do with housing. Did they have a car that was damaged? Did they lose their micro refrigerator, their washer, their dryer, their clothing, their bed? We've had terminal clients that might have had oxygen tanks. They needed a generator. I mean, anything that you can think of that is not damage to your house is the other needs assistance. So in FEMA IHP, the thing that you're going to see beyond this temporary housing assistance, you know, clients might end up staying in a hotel for an extended time. They might end up being in an apartment. Their home is being repaired. A lot of renters will be displaced, and we'll talk about that a little bit with the landlord-tenant issues. But repair, work the survivors through the appeals process, get as they can to help put their home back together, make it safe, sanitary, and affordable. If you're joining us, if you will please mute your phones, we cut down the background noise. Placement. Some clients' entire homes will not be there anymore. So we're trying to get them the maximum amount of money so that they can repair their home if the FEMA money does not even come close for them replacing their home, or the volunteer money, the private money that comes in order for your clients to be eligible to get an entire home, either site built or a manufactured home. If your client had a recreational vehicle, there might be a volunteer group that's willing to buy them a new one. They've gone through this process. Those volunteer groups are going to say, how much FEMA money did you get? How did you spend it? If you haven't spent it, let's spend it. You know, everyone's trying to conserve the resources. At Texas RioGrande Legal Aid, we have been very, very fortunate that we have been able to assist clients with getting literally brand new home. When they go to start repairing their home, the municipal regulations in place that require that it come up to current code. Well, many of our clients' homes were not in code prior to the disaster. So the repair is going to be much more expensive on the back end because they're going to have to update electrical, they're going to have to update plumbing. So that's very important. And then on the other needs assistance side of that, you're going to have a lot of clients with medical and dental needs. They might have lost all their insulin. They might have lost any other kind of medical devices. The only car that they had, personal property. Literally, we've had clients, you know, after the hurricane that had no clothing, no dry blankets. They have a tarp on their roof. It rains, everything gets wet. So that assistance is so important too. The authority, these different programs we're talking about with the FEMA individual household program. All right, the process and eligibility. Okay, so right now this is where your survivors and clients are. They should be applying. If they haven't applied and you come into contact with them, please encourage them to go ahead and apply. If they are referred for an SBA loan, a small business administration disaster loan, they might say there's no way in heck I could qualify. Encourage them because they have to at least show that they applied and they were turned down in order to move forward in some of these processes. Or, like I said, later on with the volunteer money, those volunteer groups are going to go, well, did you attempt to get an SBA loan, a low interest loan at something that you can afford? Majority of our clients, income-wise, were not eligible, but they still have to show that denial. Some of them were eligible and were able to help them through the process. Some were denied for various reasons. We'll talk about that in a little bit. And we were able to clear up some of the discrepancies that then made them eligible for a loan that helped them rebuild their home or replace everything in their home. So we also found that after a disaster, you know, if your clients miss the deadline to register and or miss the deadline to appeal, it hurts to go ahead and file something anyway and say, these are the circumstances, this is why they haven't registered yet, they've been in the hospital, somebody needed open heart surgery, somebody died, they were displaced out of county, out of state. Take the position that it's never too late. You want to stick with hard and fast deadlines, but at the same time, give it the old college try and put something in there for your clients that said, this is why they haven't done it, this is why it's late, and this is why we still should be considered. And we did see many, many times that even after the fact, registrations were accepted or appeals were accepted. Now, the further you get out from the disaster, unfortunately, you will see everybody gets a little less sympathetic. Volunteers, you know, start to wane. Life starts to get back to normal for most people if your survivors are still hurting. So make sure everybody's getting registered. Eligibility requirements in order to qualify for FEMA. Texas RioGrande Legal Aid, many of our clients live along the border, and they might only have perhaps a minor child who's a U.S. citizen or something of that nature. But if there's a minor child in the house, they can be the applicant. We're technically our clients. So, but there are privacy considerations. If there's, you know, there's some people that don't want the government their information for various reasons. So, you know, if you have a client or a survivor that has concerns, you need to be aware that they're information sharing. So that's to take into account, but that's not an issue we've seen yet. You know, our clients that had minor children or other family members that were applicants were able to get qualified. Some of the considerations for FEMA IHP eligibility considerations, you can't duplicate benefits. They can't duplicate benefits. So if your client is receiving one assistance in one area, they can't receive something that's going to double it. Or if they have insurance proceeds, they can't also get FEMA money. So it's kind of like, no, we see that as double dipping. And if you go to the FEMA websites, there's, you know, charts that talk about duplication of benefits. If your client gets rental assistance, but they're already a Section 8 housing recipient, they have to choose one other. Are they going to take the Section 8 voucher, or are they going to take the the rental assistance. So that's what that's referring to. Most of your clients, I mean, they're in the disaster area, and y'all have y'all's disaster declarations. We're not worried about that. The big areas for appeal that a lot of us saw right here, they're going to inspect the home. They're going to decide whether the home is uninhabitable or not. Well, sometimes what FEMA thinks is uninhabitable and what we actually think you live in or safely live in sometimes can be, sadly, two different things. So you will see a lot of your clients being denied because FEMA says, no, the home is not unsafe to occupy. And then their advocacy comes in, and we'll talk about that a little bit later in the appeals process. A biggie that we saw was verification of ownership. Not as simple as, this is my home, I have the deed to it, I bought it, I have a mortgage in it, my name on the tax roll, name's at the appraisal district, my address matches my main address, matches my driver's license, matches, whatever. Many times what we had seen is that clients had inherited the property family informally and never went through any kind of formal deed process or probate process or real estate transaction to close on the property. But, it was a lot of contract for deeds, a lot of verbal agreements. So verification of ownership. We had many, many, many clients that were turned down on the front end because FEMA said, no, that you're not the owner. We looked at the appraisal district and your name's not in there. Well, it might have been somebody in their family generations back. If we can, we'll look in the program guidance. FEMA offers something called owner status. So you can prove that you've, paid for the maintenance of the home, that you've lived the home regularly, that you are not paying rent to anybody, that you're responsible for the property taxes. There are ways around that with utility bills. Like I said, driver's license, address, there are ways around that. So, but those are the two biggies for getting inspections. So FEMA inspector right now is coming out to survivors' homes, and they're taking a look at everything. Sometimes the inspectors rush through the process. Sometimes they're on a kind of a quote basis, as many they can get done as possible. They might be temporary employees that FEMA just hired. They might not necessarily have a lot of training and or production experience, or it can be a variety of things. The inspections on the first time around, right after disaster, can be very cursory. So that's another reason why we're encouraging people to appeal. We'll talk about getting a second inspection in a second, but that's important. Those inspectors on the front end, it might not be the best inspection. They might miss a lot of things. Again, verify ownership and occupancy, that is a big one. FEMA think their client didn't actually live there at the time of the disaster. Might look vacant, but that doesn't mean somebody didn't necessarily live there. It just might be the notice of how they live. So that's an important one too. If your clients can't be there for the inspection, they need to designate somebody. There always needs to be somebody on site to kind of walk around with the inspector and show them and make sure they're able to document the damage. Like I said, not all of the FEMA inspectors are employees. A lot of them are just contractors and whatnot. They're not going to many times do a very intensive inspection, so it's going to fall on your client after the fact if they've either given too low of an award or if denied. For the appeals process and the advocacy comes in, that you can really put together a really nice view for FEMA of the true damages if the inspection was lacking. After the inspection, so this is probably where your survivors are now. Some of them have already been inspected. Obviously, some of them are still applying for benefits, but going to be about in the same. I think you guys are about 10, 12, 14 days out from the disaster. So some of them might already start receiving letters, and it's to say we need more information, we need more documentation of your ownership, of your occupancy, or we need more, don't think that your home is unsafe, we don't think there's enough damage. Some of them might start receiving little bitty checks saying here's $250 for your personal property, here's $5 for your home repair assistance. And in many cases, that is not going to be anywhere close to what clients need to kind of moving forward in the recovery process. All right. So if your clients do money and they're satisfied with that amount, and or they are going to appeal, but they need to start spending it forward, they need to keep receipts, they need to keep bills. Everything needs to be in a written form because FEMA can audit them. and go and do a recoup process. So after the disaster, the dust settles, 2 years out from Hurricane Harvey, 3 years out from Hurricane Harvey, we will eventually, and we do have a few cases as FEMA's back and saying, okay, we gave you $1,000 to fix this, this, and that. Show us that's what you spent it on. We gave you so many thousands of dollars to live in a rental while you fix your house. Show us that documentation. So if your client gets an award that they are not satisfied with, or they get denied outright, we absolutely encourage them to appeal, and hopefully the advocate can assist them with that. It needs to be written, it needs to be faxed or postmarked within 60 days of their decision letter. So they get a decision letter, everybody knows what the 60-day deadline is. I usually send mine a couple days ahead if it falls on a weekend, just to be on the safe side. We always encourage everybody to appeal, and I'm going to have some more details in here. In the materials, I have examples of what our authorization looks like, what a file request looks like, what a cover appeal looks like, the client's declaration. We have examples of all that. We have had clients that were still waiting on contractor bids, where it says something timely, and many times I would file, and the rest would just file maybe a one-page thing that says, look, our client has applied, they know the decision, the 60 days is coming up, but we're staying on this information, and kind of like holding their place and saying we do. Filing something is better than not filing anything. And I've had success with, even if they pass the 60-day deadline, even though we try to make that deadline, that we can just file something. Send FEMA some kind of one-pager saying they do want to appeal and they will be appealing. And then good cause. Good cause comes down to humanizing your client, humanizing the survivor. I mean, it gets overwhelming in the numbers of people that need assistance, but for those clients that you're assisting, how can you clearly explain how they've been affected and why they so desperately need me and the SBA loan and everything to move forward in their recovery? What is going to get them back on track? So today, during Hurricane Harvey, we keep a running total. We were able to help our clients get $971,000 approximately. The pro bono attorneys that helped us were able to get our clients $102,000. So our total fee money that we were able to get clients that would have otherwise been up, asked for additional money, or would have said I was denied, and denial reasons could be defied. So $1 million and something on the table that we were able to get for those clients. So for most of our clients, it was a life-changing amount of money to help them move forward in their recovery. Or in FEMA issues, navigating the bureaucracy. So disaster survivors, they're traumatized by the disaster itself. They're worried about their families. They're worried about work. They're worried about food. They're worried about shelter. They're worried about getting sick, or they already sick. There's so many things that they're worried about. FEMA is just one of many, many agencies that they might be dealing with. All of them have long applications. We need this from you. We need you to fax that. We need copies of this. The process wears people down. We've had a lot of clients that, but for helping them or but for us encouraging them, would have given up. And we don't want them to give up. And we all have that feeling where we know sometimes that it just, I'm done. I can't fill out another piece of paper. I can't answer another question. I don't want to deal with this anymore. So a lot of times, an advocate, you're really helping them get through that process and help them navigate through the different channels of all the different things that they have to do. The acronyms alone, there's still acronyms that I'm teaching myself that I dealt with. There's an acronym for everything. So letters are not very clear. You might call into FEMA one time and get some answer, and then you might call back 10 minutes later or the next day and you get their answer. And it's just sometimes the byproduct of one with a very large governmental agency. So we always encourage, if we can help somebody through the appeal process, through the FEMA process, we have found that sometimes they're successful because they have somebody to kind of walk through with them. If you do end up filing appeals for your clients, and or your client has come to you and said, I filed an appeal, I haven't heard anything, if I get denied or if I need more money, will you help me? Isn't good news. Your clients do have heard something quickly. If they have not heard something, definitely squeaky wheel comes into play if you're calling FEMA on their behalf or if they're calling FEMA on their own behalf. But just winning out and going, I hadn't heard, they must still be considering it, that's not necessarily true. everything. We also send it certified mail. There have been times I've had to prove to FEMA that no, here's my fax confirmation, here's my certified mail receipt. We did send it. Things get lost in the mix. We order a file for everything so that we can make sure all of our material has been received by FEMA. Might have been received for an SBA, might have been referred for an SBA loan that they had to apply for and get turned down for, but they never did. So just sitting and waiting isn't necessarily a good strategy. I would mail something in, I'd give it a week, 2 weeks, and then I'd start calling and check it. Okay, so denied housing assistance due to insufficient damage. That was a biggie that we saw, and like I said, what most consider insufficient damage and what our clients were actually living home safe to occupy. I mean, sadly, the destruction after Harvey, and I'm sure okay, breaking up and y'all can't hear me. 1 second. Hear me okay? I'm everybody again. I'm going to. There's many people not cooperating. Let's try this again. Okay. A lot of times your clients will be issued denials that sound like lack of cooperation. Sometimes with withdrawal their application for assistance because they said that they couldn't meet with an inspector. It's so important to make sure you know when the inspectors come in or designate somebody to be there. Sometimes with rental assistance, the clients, they don't want their house even though they should, and they're not to accept the rental assistance if they need it because they're afraid to. Maybe coming on, if you could please mute yourselves. So that background noise. For failure to verify ownership. Feedback that my sound breaking up. So according, I'm going to try to get through the material. And hopefully when you go back and review it, you'll be able to hear it clearly. After everybody, unmute everybody. I'm going to keep working my way through before we move on to the next portion. We'll try with the sound and the muting of everybody. There to verify ownership, you will see that bit clients think that they're the legal owner, but FEMA standards they're not. So there's a lot of room for advocacy to help clients show that they have occupied status. And sometimes once you can just clear that issue up, they are eligible for assistance moving forward. So very, very often was duplicate or shared household rule. You can only have one head of household. So you might have one address out in the country that has 2 or 3 different family members living there in 2 or 3 different households, but they all share one box, one address. So there's a lot of advocacy that you can do to show this is the address, but if you look at the CAD, there's this property and there's this property, or there's this tax account, or their driver's license hasn't been updated, you know, a lot of things like that. But in rural areas, your client will run into this if they have one address and several different properties, different households on one address. So you can have them through that so that they can be eligible. We had FEMA clients that were distanced because FEMA told them they had insurance. If they have insurance, the insurance did not cover wind, it did not cover flood, or did not cover contents of their home. So sometimes working them through their insurance policy, out what the policy actually covered, and then helping them communicate that was very important. Or if there was a language barrier, if our clients were, and this is something that we're still seeing, our clients are not English speakers, but FEMA was doing everything to them in English, that would be a problem. So we're still working on those issues, and you'll see that. Client might have had a flood issue several years ago, and FEMA did a requirement that they now maintain flood insurance, but they did not maintain the flood insurance, and they're going to be denied this time around. So there's some issues there with flood insurance. Property. Clients were deemed to have minimal needs, or they were given a very, very low money. So the process will help them go through that. Exhaust estimate. If anybody can, please. As they're going through the process, trying to get additional money to replace the actual contents of their home if those were uninsured, that can then go on into an administrative process, eventually up to, in Texas, if they had it set up to where it could eventually go on to the district courts. But I know it's going to be a little bit different in Tennessee, and you guys can look into that. But there is a process to continue appealing the denial or under awards for other needs assistance, everything that doesn't have to do with the actual structure of the home. Transportation assistance, if your client had a vehicle badly damaged or completely destroyed during the disaster, and our clients were denied because their cars, a FEMA regulation, their car had to be legal to drive on the date of the disaster. Some of my clients did not have updated insurance, and they did not have updated registration. And when we talk about post-disaster legal needs in a little bit, we'll talk about preparation for the next disaster. Or they couldn't prove that the vehicle was essential for them getting to work or something like that. But for the clients that were able to apply for and receive transportation assistance, them for advocates. Evaluate the issues. There's a lot of avenues for advocacy for you to be able to help your clients put this together. They've been traumatized by the disaster. They don't have access to internet. They are not unable to print color pictures. They don't have access to a fax. Some of my transportation. So having an attorney advocate to put a really comprehensive appeal for them with exhibits and pictures, between them getting no money, a lot of money to start moving forward on their in an appeal packet, FEMA number, their disaster number, advocate's cover letter, and we've included examples of these, the materials for the meeting. The more information you can put in there, the better, to show that their home is not safe to occupy or how heavily damaged it was by the hurricane, the more the better. Mail fax, sometimes if you go to fax in pictures, you can see the details. We fax everything, fax receipt, and then we also certified mail every single FEMA appeal that we do. And then that way FEMA has those colored pictures available to them to review when they're making a decision. Your appeal for your client to be considered within 9 days, but you should check on that. Call. FEMA did, in fact, receive it, that it's being considered by somebody, and to keep asking for a written decision so that they can move forward into the next process. Stay in communication with your clients. If you receive anything from FEMA, they need to let you know immediately. FEMA will contact them. They're not going to contact you, even though you are representing them through that appeals process. So you stay in contact with your client. Sometimes they have had to move far home. They don't have the best communication capabilities with their phones. You know, is there a family member that you can call to get in touch with them? They can call you back. I mean, however you have to do to be creative to stay in touch with them while they're working their way through this process. It's denied. You've helped a client with an appeal, or they've appealed on their own and they've come to you. Can you appeal again? Regulations that say once you've one appeal denial, the decision is final. However, if you're creative and if you are tenacious and you come up with something new or something for FEMA, there were many times with some of our clients that we did appeal once and we were successful. If you think the decision is wrong, what can you give FEMA that gives them something to make a positive decision for your client, for either awarding them additional assistance or assistance at all? So when it took the don't give unless we really, really had to stop the appeal process with our clients, and we were successful. Okay. Some people think that survivors don't need a lawyer to help them through the appeals process. We have found that the client had attorneys working with them were more successful in this. Sometimes people are not able to navigate that alone, or we talked about the survivor fatigue. They've been through a lot and they need somebody to keep them moving. All having an attorney with these clients on the front end while they're navigating the FEMA process, those issues or those other legal problems are going to start to crop up. Have an attorney on the front end, it might help them for the mid-legal issues and the issues, or you can say, you know what, this is going to be a problem. You might need to go ahead and start taking care of this. You're, behind on your property taxes. You've never applied for a, property tax exemption. When volunteer groups made in to make up the difference that FEMA didn't give you to help you repair your home, a lot of those volunteer groups are going to ask, are you current on your property taxes? There's a whole host of things that need to be straightened out and cleared up before we move forward, and we'll talk about some of that in a second. FEMA's message many times about appeals is it's really easy. It's not a process, just a few papers and you're done, and it's really not that simple. So if we are able to provide assistance for survivors and help them through the process, we really do. Just because it says that it's easy, that doesn't necessarily make it so. All of our clients are on a very different spectrum of where they are education-wise. Some of our clients can read, some of our clients can't read. I mean, there's just a whole host, and we talked about the barriers with access to internet, and some of them have access to a fax machine or various things. Emailing a document, certified mail for some clients is difficult, especially given what they've been through. So having somebody to do that, especially an attorney that is used to handling those types of things, can make the difference between them being successful or not, moving for recovery. If the audio has been bad, I apologize. I'm recording this, hopefully here. Otherwise, anybody in our group is available by phone or email to answer questions after the training. Okay. If everybody could please
is there an
mute.
option for a non-insert? Like, is there another option, or is it just
Okay. I'm going
Oh, of course. No, thank you so much.
Thank you, Kerry. Hopefully everybody can hear me now. Work of contacts. As attorneys, we know a lot of people in different roles. Sometimes that is the best thing that we can do for our client is where to refer them to. Eventually, when the recovery process turns into a long-term recovery process and there are disaster case managers of the clients, some of this can be taken off the attorneys, but on the front end, when you're first start disaster survivors, they're going to look to you as the expert on everything. Where can I get a tarp for my roof? Where can I clean clothes? Where can I get dry clothes? Where can I get meals? Where can I apply? What can I do? So having a wide network of contacts and being plugged into your local communities is very helpful to your clients as you help them navigate after a disaster. Talk about the different short-term, mid-term, and long-term needs. We are still in the long for many of our clients here after Harvey. Needs. Cam and Kerry are going to speak to this more with tenant law, but what you're seeing is a lot of landlord-tenant issues. Renters that are in homes that are unsafe to occupy. The landlord says, you can't come back. I'm locked door. I'm throwing all your stuff out. I don't have insurance to fix this. I don't want it to be a liability. Or keep your security deposit. I'm not going to fix anything. Sorry, you're on your own. Maybe some verbal leases that haven't been renewed or never renewed. That's a big one. So I'm going to let the ladies speak to that in a little bit. May have had documentation during the semester. So in order to apply for things, they might need to go get their driver's license redone, or their social security card, or they can't find a birth certificate. So replacing important documents, they're going to need with that. Financial assistance, that all comes in right there with the immediate money and FEMA appeals process right there. They want to know where they can apply, how they can immediately get some money to start moving forward if they didn't have insurance, or if they were underinsured, or insurance didn't cover the damage to their home. So we just went through this, so I'm not going to go into that anymore. But a portion of the early legal survivors, legal needs. Continue on with landlord-tenant questions, and now there might start being eviction issues coming up. Title to homes, we talked about this a second ago. When FEMA, you kind of have an idea when FEMA starts denying people because they're unable to verify ownership. We are still clearing title to homes 2 years after Hurricane Harvey so that our clients can qualify for housing assistance, either repair or replacement. But we're having to probate wills, we're having to do muniments of title, we're having to do affidavits of heirship, and I know those are all Texas things. I know y'all have something comparable there, but title clearing and deed work is a portion of that. Our manufactured homes have an agency that handles that titling. I believe in y'all state it is the Department of Revenue. So you might have bought a manufactured home, put it in their property, but had the title. The person that sold it to them never had the title, so we're going back 2 or 3 or more sales. There might be liens on the property that's preventing the title from being updated, so we have to how we get those liens released or what we have to do with that. Dealing with mortgage companies trying to prevent foreclosures. Sorry about that. Administrative cases. Clients have applied. They're still trying to get additional money. They might need additional rental assistance because their home is not safe to return to yet. They might be seeking extensions on hotel vouchers, or if they've been denied and we're trying to increase that amount of assistance. With private money that comes in or other programs, they're going to look first to what did FEMA say your loss was. So again, if people don't want to apply with FEMA or they don't want to deal with FEMA, it's so important for things that they might try to do after with private money. Do people have insurance? What did it cover? They now want to try to get insurance. There might be a bunch of issues with the insurance company. Disaster loans, people get denied for those, helping them through the process. For some clients that actually qualified for loans and it was a considerable amount of money and it was a really good interest rate and it was really low payment, closing of that loan could be very difficult. It is a stack of paper. It's like closing home. I mean, it is a lot of documentation, a lot of legal documentation, and so just helping your clients go through that process, sit down and explain what it means to them, what the repayment terms are, what are some of the things that could happen if they don't hold their side of the deal, take that loan or not. Fraud, big one. Had clients that didn't ask for a new roof. A contractor put it on their home, and then they're being sued now for a roof that they didn't even want, or workmanship, or client pays for half the roof again. I mean, different things like that. You're going to see a lot of consumer issues. Employment, disaster unemployment insurance. We had clients that were terminated from their employment because they heeded the mandatory evacuation orders. So those cases that are still being, filled out in the unemployment realm. Human keen, unfortunately, that's some issues that we worry about. Family law. People move to a county that's outside where they're supposed to be able to live or where their children are supposed to attend schools. You're going to see some family law issues start coming up. Domestic violence, people are tax, and sometimes issues start to crop up as well. Legal setback can lead to more. So your clients are fatigued, they're worried, they're tired, and we're just trying to keep them moving forward. Long-term legal needs, foreclosures, debt collection, bankruptcy. I had mentioned earlier FEMA recoupment. Your client gets money. It's a satisfactory amount of money. Did they save their receipts? Did they give accurate information to FEMA on the end? Can they prove that they spent the money what said that they were going to spend it on? The title clearing, I can't stress that enough. I've spent 80% of my caseload this last year used to be title clearing. There's still private money available that can assist my clients. I have to get them through all of the different qualifying processes, and all of that comes down to title. Do you own that piece of real property? Did you own that home? Do you have title to that home? The things. Recovery, preparation. Ultimately, you'll want to get your clients to the point where they have moved forward. They've overcome all the barriers to their recovery, and now helping them prepare for the next disaster. There's going to be another disaster. So if you were to have to go through this tornado again, or if you were have to go through this hurricane again, we did a community ed push to our clients. Maybe they weren't survivors, but they lived in the community. They saw their neighbors and family members suffer through this. We'd say, look, do you have title to your home? Have you probated a will? Do you have a will? Is your name on the tax accounts at the appraisal district? There's so many things that a lot of people just have lined up. Have taken an inventory of your property. Do you have receipts for any large purchases? If you were to lose your, refrigerator tomorrow, can you prove how much it's worth and you bought it? So we're still in the recovery phase, the long-term recovery phase here after the hurricane, but there's also a sense of if I have spent 2 years clearing property for a client and they've now gotten a new home, newly built, safe, new home, I'm doing estate planning for them. I want them to have a will or some other means of being able to make title goes to the next generation so that there is a tornado or a hurricane, the number that is set to inherit that home is not in the same position that my client was when Harvey hit. So we know that with disasters, it's going to be if, it's just going to be when and how bad. I've been with TRA for a little over 2 years full time now. I've been through a hurricane, multiple floods. All of our disaster assistance team members assisted with mass shooting out in El Paso. We try to assist as many states as we can with their kind of disaster planning and recovery, but it's really not if, but it's when. So I hope everybody could hear this. I'm going to sharing this and go back over so I can turn it over to if you would mute, I'd be happy to try to answer a few questions, or you can chat them in. If everybody would mute, I'd be happy to try to answer a few questions, or you can chat them in. If everybody would mute, I can take a few questions. Otherwise, I'll hand it over to Kerry. Kerry, I'm going to go ahead and make you the presenter. All right, Kerry. Very much.
All right. Well, thank you, Dina. And if you could, your microphone and make sure that you're muted. So that all. Well, I'm hearing a little background noise, so please, if everybody could take a look at your microphone, make sure that it's muted. Sounds a little better, so I'm going to go. It looks like maybe we got everybody muted. So, hi, everyone. Thank you, Dina, and thanks to everyone for showing up today. I appreciate your willingness to jump in and help your community members after the tornado. My name is Kerry Dietz, and I am a housing and consumer attorney here with Legal Aid Society of Middle Tennessee and the Cumberlands. I am in our Nashville office here, and I am a native Nashvilleian myself, and have really enjoyed the opportunity over the last 3 years to get to work with Legal Aid and get to help our clients. And so I am going to do a brief high point overview of Tennessee landlord-tenant law. I've got some handouts that I believe were sent around, so check in your email for those. I may reference references as we go throughout, and at the end I have a slide listing them. And then I've got one brief slide, if we've got time, on just home ownership issues and to flesh out a little bit about kind of avoiding scams and contractors and whatnot, and so just kind of have a few tips that I've heard along the way over the last 2 weeks that I wanted to share with y'all. All right, so in Tennessee, landlord-tenant law is primarily governed by Tennessee's Uniform Residential Landlord-Tenant Act, also known as the URLTA or URLTA. It is found at TCA 66-28101 et sec. It doesn't cover every county in Tennessee, but it does cover counties with a population of over 75,000 based on data collected in the 2010 census. And importantly for our post-tornado efforts, that does include all of the counties that were most affected by the tornadoes. So Davidson, Wilson, and Putnam counties are all URLTA counties. So that statute is what's going to apply in those counties. In other more rural counties with smaller populations, you're pretty much relying on common law. So under URLTA, lease agreements can be written or verbal, oral. They don't have to be written. If someone has been paying rent to someone else to, have possession of a property over time, they can develop a tenancy whether or not they have a written lease. If it is one of those oral agreements, then usually that's going to create a month-to-month tenancy. And so that means that there's no term protection of a lease. It's not a lease for a year, but it's a lease month-to-month. And so that means that the landlord can terminate the tenancy with a month's notice. And we'll talk a bit more about notice specifics ahead. Actually, tenants cannot waive protections in URLTA even if the lease states that the protections are waived. Those protections in URLTA are going to apply if the contract says otherwise. So that is a crucial point to keep in mind. Let's see. There we go. Listed out some of the other you may want to look to get a better understanding of landlord-tenant law. The first one up there is the Forcible Entry and Detainer Statute, and so that's kind of the process overview of what happens. A detainer warrant is what gets filed in an eviction, and so that statute kind of overviews the process and what it means. There's also another provision in the Tennessee Code that talks about notice required for terminating leases. That same information is in URLTA as well, but it's a little spread out. And there are two cases that I've listed that are really helpful, both cases from the Tennessee Court of Appeals that can be really helpful if you're new to landlord-tenant law and just kind of want to get an understanding of what's going on. Those are both good, offer some good arguments and perspective in favor of tenants. Some notice, some about conditions, but they're two good cases that break it down and make it helpful for you, especially if you're just trying to get context. In a situation like this, post-tornado, are really looking to this casualty provision of URLTA. And so the threshold question for a tenant who is living in a property that was damaged by the tornado is, can the tenant live in the home during the repairs? Is the unit still habitable despite the damage from the tornado? If the place is still habitable, then the normal laws apply. Landlords may not force out tenants without going through the legal eviction process, and they have to take it step by step. If the unit is not habitable because of the damage from the tornado, this also applies to things like fires or floods, any sort of disaster that has caused significant damage to a residence. So if it's not habitable, if the tenant cannot stay there and the landlord has to get the tenant out in order to do the necessary repairs to address the damage, then the casualty provision applies. And critically, under that provision, either the landlord or the tenant can opt to terminate the lease. So even if there is a lease for a year, if the unit is not habitable and the landlord cannot make the necessary repairs to the unit while the tenant is living there, then either the tenant or the landlord can give written notice and terminate the lease agreement. If that happens, if the lease is terminated by either party, it's important to keep in mind that the tenant is entitled to recover any prepaid rent prorated to the date that they vacated the property or the date that the keys were returned to the landlord, whichever of those is earliest. A tenant can go ahead and vacate the property. They don't have to wait 14 days for the notice. And the other thing that's important to keep in mind is that tenants, if the lease is terminated, should be entitled to the return of their security deposit pursuant to the provision under URLTA that governs security deposits. Depending on how bad the damage is, tenant caused damage may not be an issue, but that right there, 66-28-301 details the process and the guidelines for handling security deposits. Some general information about property conditions and repairs. Under URLTA, the landlord has an obligation to make repairs necessary to keep the rental unit habitable and in compliance with any health and build codes related to safety. So generally what that means is the unit must have working plumbing, it must have water, heat, power, utilities, sewage, anything else that applies. There needs to be safe electrical wiring, and the structure should be able to withstand weather. And so just what that means is that the structure is complete and the unit is completely protected from the outdoor elements. So if there's a hole in the roof or the wall, something like that that exposes the unit to outdoor elements, that's not going to be habitable. Have a duty to keep common areas clean and safe. If it is a multifamily property, the landlord is obligated to maintain those common areas. For necessary repairs that a tenant identifies that a landlord needs to do, those requests should always be made in writing. Under Tennessee law, the tenant is not entitled to follow back up with a lawsuit over repairs that haven't been completed unless they've given that written notice first. And if anyone is just joining, reminder, please check your microphone and make sure that it's muted so that everyone can hear. We're relying on y'all to do that. Thank you. For repairs, their normal non-essential repairs, the landlord has 14 days to make the repair after they get notice.
Take a picture of it so you don't need it next time.
Would everyone please make sure that you have muted your microphones? That would be great. I'm still hearing a little background noise. Appreciate it. Thank you all for your patience. So if it is an essential repair like heat or water, an issue that's under the landlord's control, I know a lot of us know that it has taken the electrical utilities.
Her name on top. Okay, erase. Go ahead, send it right here.
I'm sorry. Hi. Whatever, please check your microphone and make sure that it's muted. Thank you. If it is one of those essential repairs and it's something that is within the landlord's control.
Really clearly, really big. Okay, that is not really clear. Remember, the post office was trying to read it. That's nice here.
Hello, I'm so sorry to keep repeating this for those of you that are compliant. Please, everyone, please check your microphone.
Really
Please microphone and make sure that you are muted so that everyone hear what's going on.
Nashville. Change the code.
Okay. So for those essential repairs like heat or water, if the landlord can do something to fix it, the landlord needs to do that within 2 days. They need to go ahead and take care of that. Obviously, as I was saying, we know that a lot of the electrical utilities in the areas that have been really damaged by the tornado have worked overtime to try and restore electricity to all the residents who have been affected. But of course, when transformers are blown and power lines thrown across the street, that's not something that's within a landlord's control. And so, in that situation, the tenant really needs to just wait for the utility service to fix it. If the landlord does not make the repairs within the appropriate time frame, the tenant may be able to break the lease and move out. It's a little tricky, certainly. If you ever run into anybody who's in a situation like that, please feel free to refer them to our office. We are happy to help walk tenants through that process and make sure that they are doing everything right and don't end up on the hook for damages than they should. It's one of those essential services. The tenant may be able to move out and recover costs for substitute housing from the landlord, or they can make the repairs themselves and deduct that cost from their rent. Again, that can be a little tricky, and I recommend referring anyone in that kind of situation to their local legal aid office to get some help with that, to make sure that they're doing it the right way. Very crucially and important to keep in mind is that under Tennessee law, there is no right for a tenant to withhold rent due to repair the landlord is not making. Under laws in other states, tenants will sometimes have the right to withhold their rent, and unfortunately, a lot of times we will hear from people who said they Googled and read online that they were entitled to withhold their rent if their landlord wasn't making repairs, and so they went ahead and did that. And unfortunately, in Tennessee, that's pretty much a one-way ticket to getting yourself evicted. This provision for essential services, with the being able to move out and then recover for substitute housing or to make the repairs themselves and deduct the cost from their rent, that's really the closest thing in Tennessee law to that type of situation. And again, it's very narrow, and you have to do everything correctly. No general right for tenants to withhold their rent. So that means that tenants must keep making their rent payments, even if the landlord is not making repairs. They need to. It's very important for tenants to go through the proper legal process, so that they are protected and don't end up getting evicted or being charged with excessive damages. So the exception to the landlord's obligations on repairs is that the landlord doesn't have to pay for the repairs. They charge the tenant for the repairs, and under certain circumstances evict the tenant over repairs if the damage necessitating the repair was caused by the tenant or one of the tenant's guests. So basically anybody who is visiting the tenant's home with the tenant's permission is included under that as well. And like we talked about just a minute ago, if the damages are so extensive that the landlord can't make the repairs with the tenant there, then that casualty provision is going to and either the landlord or the tenant can opt to terminate the lease after written notice. So here's an overview of the eviction process. The first step in most evictions is going to be the tenant receives written notice of lease termination. So under most circumstances, a landlord has to provide written notice to tenants saying that their lease is terminated before the landlord is entitled to go to court, file a detainer warrant against tenant. Exception to that, and this is detailed in URLTA, is that are not obligated to provide written notice first if the basis for the eviction is non-payment of rent and the written lease agreement between the landlord and the tenant has a valid waiver. So in order to take advantage of that exception, the lease agreement has got to have pretty clear, the statute actually specifies at least 12-point bold font stating that notice is waived in cases of non-payment of rent. Under circumstances, can tenants waive their right to notice? See leases that say notice is waived for everything, and that's just not following law. They're really not entitled to do that under all other circumstances. They've got to start with that written termination of the lease. And for more information on that, you can check out those two cases that I cited earlier on. Those kind of explain that process and why it's so important really well. So the length of notice that is required depends on the type of the agreement, when it was created, and the type of the violation that the tenant has allegedly committed. A cite in there to the provision of URLTA that talks about enforcing, lease violations and tenant terminations against tenants. So the shortest written notice that may be provided is 3 days, and that is really reserved for times that the landlord reasonably believes that the tenant, someone in the tenant's household or guest, poses an ongoing threat to the health, safety, and welfare of others on the property or to the property itself. So unless they have reason to believe that the tenant is posing a threat to someone else on the property or to other parts of the property, the tenant running their car into things or whatnot, that 3-day notice is not going to apply. And that is the shortest possible notice, other than no notice if there's a valid waiver for non-payment of lease. So another common type of notice that you'll see are for curable violations of the rental agreement. And curable just means that it is something that the tenant can fix. Maybe the tenant has a pet and they're not supposed to have a pet, or maybe the tenant owes some back rent. So anything that can be remedied by the tenant is one of those curable violations, and in those cases, you'll see usually what's called a 14/30-day notice. Actually changed on this about 10 years ago, and after 2011, the General Assembly changed this part of law. So sometimes you'll still see leases that incorporate 7/14-day curable notices. For the most part, you're going to see 14/30-day notices, and what that is the tenant gets written notice outlining what the violation is and letting them know that they have 14 days in which to cure whatever the violation is, pay the back rent, out their pet, kick out the person that's not on the lease that they've been letting stay there, whatever it is. And then if the tenant fails to cure the violation within 14 days, the tenant terminates after 30 days. For non-curable violations of the rental agreement, normally you're looking at 14 or 30 days. 14 days if the landlord doesn't provide an opportunity to cure, or, you know, it's important to look at the lease and just kind of see what's in there. There may be stronger protections in there, or there may not be. So it's just important to look there. But if the landlord does not have an opportunity to cure, or it's something that cannot be cured, usually you're looking at 14 or 30 days. 30 days, you'll see 3-day notice a lot. Also is what applies in situations without a lease, or if someone is on a month-to-month lease, usually it's 30 days notice. If someone's on a week-to-week lease, and they're paying rent weekly versus monthly, then they have 10 days. But is what you'll see a lot if, you know, there may not even necessarily be a violation, but the landlord may say, I mean, your tenancy in 30 days. Crucially, when that happens, it has to be to cover basically a full tenancy period, so a full month. If a landlord provides notice, a 30-day notice in the middle of the month, they won't be effective until the end of the next month because it has to coincide with a 1-month term. So that lease termination period expires however long it is, then the landlord must go to court to get a detainer warrant in order to proceed with the eviction. At that point, a hearing on the detainer warrant will be set. It cannot be less than 6 days after the issuance of the detainer warrant. So then the landlord and the tenant will go to court. If the landlord wins in court, the tenant still has 10 days to move. So typically on a detainer warrant, you'll see 2 types of legal issues. One is over possession of the property. Who is entitled to possession of the property? Can the tenant continue to live there, or may the landlord kick them out? The other issue is damages, and so that's, you know, who owes who what money. So the landlord does get a judgment for possession against a tenant in General Sessions Court. It will take 10 days for that judgment to become final. And so even once the court gives a judgment for possession to the landlord, the tenant still has 10 days to move. After those 10 days are up, if the tenant still has not moved, then the landlord has to go back to court to get a writ of possession from the court. And that is when they'll follow back up, usually with the assistance of the sheriff's department, to enforce that writ of possession. Sometimes it's also called a writ of execution or restitution. And so they'll come with that writ, and that's the time when they can actually force the tenant to move out. At no point before then, no matter what the landlord says, can the landlord force the tenant to move out. The law really frowns upon self-help or illegal evictions, and so landlords are not entitled to try and force the tenant on their own without going through this process. Sometimes you'll see landlords shut off utilities in order to force a tenant to move without going through the process, or, you know, take measures to basically just try and force the tenant out. That is very frowned upon under Tennessee law, and if anybody runs into a situation where a tenant is dealing with something like that, please refer them to a legal aid office so that we can look into that. We prioritize those types of cases, and I am worried a little bit that we're going to start seeing more of those in the next week or two while the court system is kind of on hold. So we're certainly going to keep an eye out for that, and we'll enforce the protections that are there for tenants to the extent that we can, with the courts also closed. So this is a list of the handouts that I provided along with this presentation. The first is a one-pager that was put by Legal Aid of Middle Tennessee and the Cumberlands following the tornado. It kind of overviews rights in this type of situation, mostly going to be some of the information that we talked about here. but may be helpful to to have around and to pass out. I've also provided a list of affordable housing resources for Davidson County. This is something that we hand out to almost all of our clients who need to move or would like to move. It has some information on what the affordable housing options in Davidson County are, some stations to contact for financial assistance, some emergency kind of short-term shelter type resources, and the first item on that list is a website. It's tnhousingsearch.org, and that is a database, a website. It's managed by THDA, and it has really great information, very up-to-date information about availabilities, what's open, what's not. Also has really good advanced searching options. So if you click on advanced search off of the first page, you can filter your search to a specific geographic area. You can filter specifically for properties where your rent will be based off of your income. So any property has some sort of subsidy. It's a really great place to get good up-to-date information about what's available. Of course, affordable housing resources are few and far between. It was true in Nashville before the tornado and is probably even more true now. There are really lengthy wait lists for Section 8 vouchers and for many subsidized properties. So a lot of times people need to be really persistent and patient while looking for options, get on wait lists, and maybe, think about what they can do to fill any gaps that might come up by relying on those shorter term resources like shelters. Also, along with those handouts, there is a repair request form that we at Legal Aid also send out to our clients who are having issues and need repairs. Basically, that will help the tenant comply with the written notice requirement. And it's just a list. It's bilingual, so it's also the same sheet as the language in Spanish and English. So renters can check off what issues they're dealing with that need repair, date it, sign it, and give it to the landlord. It's very important that the tenant make a copy for themselves or a photo with their phone themselves before they hand it over to the landlord so that they can show what they said and when they said it in case they do need to go to court and take more serious action over it. So a list of, there's also some information about tips and instructions for moving out of a rental property that we tend to distribute to our clients who are having to move out. It deals what the tenant's obligations are and what they can do to best make sure that they get their security deposit back. In general, a great place to look for Nashville-based resources is Where to Turn in Nashville. I'm sure a lot of you have seen the printed booklets. Open Table. There's also a website where you can go and look for resources. It has resources listed by different types, whether you need financial assistance, whether you need a shelter, what labor issue. It has all resources listed there. So that's always a great place to look for some resources to refer people to. And brief tour here. In some tips for homeowners, I was lucky enough to get to attend both of the community meetings at Lee Chapel in North Nashville a week ago yesterday on Monday that were put on by Stand Up Nashville and the Equity Alliance. Obviously, especially in North Nashville and other similar areas, there's a major concern about homeowners getting taken advantage of, people swooping in to buy and develop properties there. It's already a gentrifying area, and if the tornadoes that Nashville has suffered are any indication, then it's a prime time post-tornado for gentrification to really accelerate and for people to be forced out of their homes. So just a quick run of some of the tips that I learned from the experts who were at that meeting. To some extent, Dina already talked about this, but no one should ever sign anything under pressure. It's presented as a one-time offer, take it or leave it, leave it. Take time, read through anything before you sign it and make sure you know what's going on, who you're working with, and feel good about the choice that you're making. Never pay a contractor in cash or all up front. If disaster hit areas, it's typical for contractors to make a detailed estimate and then as a down payment charge no more than 1/3 of the cost of that detailed estimate. People need to be really cautious in terms of researching business and people before they agree to work with them or hire them. You can ask for local references, emphasis on local. If the business or person is hesitant to give those, that's a big red flag. Especially with contractors, take photos with them, take a photo of their car or truck license plate to avoid that situation. Dina mentioned earlier where a contractor, takes your down payment and then disappears. Talking to someone who is interested in buying your property, tell them that you want to talk their offer over with your realtor, whether or not you have one. This will kind of signal to them that you're being cautious and taking your time and kind of scare off some of the more shady actors out there. And your insurance may give you a list of referrals for contractors to use for damage. You do not have to use those contractors referred by your insurance. You're entitled to pick your own, take your time, work through. If something sounds too good to be true, it probably is. But make sure that you pick someone you trust and can get in touch with after you've paid your deposit and then even after the work is done. If someone does get taken advantage of or thinks that they've been scammed, it's not their fault. Unfortunately, situations like this really bring out people who think it is a good opportunity to prey on other people, unfortunately. And so they're experts at what they do. There's no shame in getting caught in getting scammed, getting caught up in one of these scams because you maybe didn't get these tips in advance. And so don't be ashamed. Report what you know to local law enforcement and know that it's not your fault, and encourage anybody that you run into in a situation like that to do that. And that is it for me. I am happy to try and take questions if that's feasible. If not, you're welcome to send them in, and I'll address them. But we're also at about my time, and I'm going to need to pass it over to Kathy Trawick here shortly.
Take care. That was awesome information. I'm going to go ahead. Kathy, are you there?
Yes, I'm here.
All right, I'm going to make you presenter so you can share your screen. And then if we have some questions at the end, maybe we'll have some time. I see a question from Tom. All right, so Kathy, you can.
Let's
If you want me to mute off, it's too much background noise for you.
Okay, can everybody see my screen? Can you see Dina?
Yes, I can.
Okay, great.
All right, I'll go ahead and mute all to get rid of the noise.
Okay. So I'm Kerry Trawick. I'm the Executive Director of the Tennessee Fair Housing Council.
Yeah.
Uh-huh.
No, go ahead.
Oh, okay. So I have been working in fair housing since 2003. Interestingly enough, this is not my first tornado. I was at West Tennessee Legal Services in 2003. 4 days after I started work there, tornadoes came through and devastated downtown Jackson, our office being one of them. And our executive director forever continued to introduce me as the person who brought the tornadoes. Our office was a lot better after that, but so this is not my first tornado, and so I can understand what a lot of people are going through. The Fair Housing Act, a lot of people don't realize just how much the Fair Housing Act can help when it comes to housing issues. It can be an important addition to your toolbox because it covers both renters and homeowners. It applies to all types of housing, whether it's subsidized or market rate. It covers all types of dwellings, in other words, where the person lives. It applies to landlords, mortgage companies, insurance companies, HOAs, and cities. And to just be giving even more than a 30,000 foot view, it's more like a 50,000 foot view, and I'm tailoring it strictly to what you might see in a disaster. The statute is found at 42 U.S.C. 3601 at SEC, and the of it is at 3604. Basically, it's illegal to treat a person differently because of race, color, religion, national origin, sex, familial status, disability. And familial status means the presence of children under the age of 18, and disability may be an actual disability or perceived. Sex, it used to just be viewed as versus female, but now it's viewed more as if a landlord perceives a person to be acting outside of the gender norm and treat them negatively, then that would fall under sex discrimination. It also covers victims of domestic violence. What you might see through this is a landlord prioritizing repairs for their white African American tenants or Hispanic tenants, return a security deposit more quickly for one group of another. And so it's important that it is because of membership. And what you're not going to hear somebody necessarily using these words, but you may hear someone saying, well, I don't know why they won't fix my roof because they fixed someone's roof. And that's when you ask questions and you try and determine if there's really a difference in treatment or if it's something that can't be helped because of the stat of the house or something. So a mortgage company offering more favorable terms for one group of borrowers over another. And this one is really important. A codes department enforcing their rules more stringently over one group than another. So I know that it is considered minority, and if more people are coming in the codes department and saying, giving shorter periods of time than another neighborhood that is considered white. That's a very important thing. Important to remember that the person must be otherwise eligible and that negative actions have to be because of membership in a protected class. And, in times of disaster, it's a little bit more difficult to tell because everything is in chaos. But it has to be that because of. This is really what's really important, and for people with disabilities have additional protections. Reasonable accommodations, which are a change to rules, policies, practices, or procedures, reasonable modifications. In the Fair Housing Act, a person with a disability, it's a physical or mental impairment that substantially limits one or more major life activity. So it could be actual diagnosis, the perception of one, or history of having a disability. And basically, as age is not a protected class, and age is they a lot of times will develop a physical limitation or a physical impairment. So bend over, or they may develop heart issues. So if they're not drawing Social Security disability, they still might qualify as a person with a disability. And I talked about one of the term situations you might encounter involves cleanup of the property when the landlord or the city sends the resident a notice of violation because the property is not cleaned up. Well, if the person has a disability that keeps them from cleaning up the property in the required amount of time, then it might be possible to request accommodation to get them more time. So in other words, if a person is elderly and they've got back issues or something and they just cannot physically make remove the items, then they've got a mobility impairment, they've got a nexus that you can show why they haven't cleaned things up. This is also important when you've got developers coming in and they use the city's reporting line and report people for minor or for repairs that haven't made, hoping to be able to get the property condemned and be able to pick it up for a song. So to help the person try to get more time, you make the reasonable accommodation stating that the person has a disability. Don't state what the disability is unless it's visible, and explain the plan to become compliant. So there's no one-size-fits-all, only available to people with disabilities. You might also find this if a person has a mental disability that's causing them to be out of compliance with the lease. And so if that's the case, then you can still make the reasonable accommodation request, but they still have to have a plan, because ultimately the reasonable accommodation is to give them the time necessary to become compliant. This is what a reasonable accommodation letter might look like if you were helping someone who still contained debris. And so basically you are making reasonable accommodation, not be fined, and that they are allowed extra time for compliance. You're explaining the manifestations of the disability, and he's contacted several agencies for assistance, but they're on the waiting list, and the wait might be several months. You have to be prepared to provide verification of the disability from either the person's doctor or therapist or a reliable third party who has actual knowledge of the disability, and also that he is in fact on the waiting list. And you want to point out that the accommodation is reasonable because it won't pose an undue financial or administrative burden, and it will fundamentally alter their program. So it's got several components to it. You're laying out that you're showing the nexus, you're providing verification, and you're adding them more time. And this also important, Kerry mentioned the gentrification issues in North Nashville, and it was at one of those meetings, and people had, even a week out of the tornado, people had been contacted by developers. And not that every developer is disreputable, but it's important that if they're using underhanded tactics like anonymously reporting resident or failed repairs or something like that, it might even be someone who didn't receive damage from the tornadoes, but they're taking advantage of all the chaos and to come back in and purchase the property at a lower price. If we can show that the developer had targeted them because of their disability, then the developer becomes liable also. If the city were to not grant a valid reasonable accommodation request, they would become responsible and could ultimately be a violation of a federal law. And that's why this is so important, is because it is a federal law and it applies to their dwelling and anybody that that deals with them. Insurance companies, it's a difference in treatment. Back in the day, there were issues where minorities was literally a red line drawn around certain neighborhoods where they could not get a mortgage, they could not get insurance. So again, basically, it is about disability. And then, like I said, that was like a really quick overview, directed mainly at what attorneys might see as far as damages from the tornado, ways that can be helped. Mind, if the person you are assisting does have a Section 8 voucher and the person must move, they have to coordinate with either NDHA or THDA the fact that they've got to move. They cannot assume that their caseworker knows that they're going to move. They've got to reach out to them, and everything has to be coordinated. If the person is being evicted, the first response of MDA or THDA is to cancel their voucher. So it's important also that they have a hearing. There are certain things that the house authorities have to go through to terminate someone's voucher, and there's also a separate hearing. And if the termination, if the eviction is because of that person's disability, maybe a mental disability, it's also possible to help them with their voucher if reasonable accommodation can be requested. So all of this is important to keep in too. And like Kerry, we work hand in hand with legal aid and talk back and forth and refer back and forth. So if you have questions, especially if you wonder if something would be a fair housing issue, I've got an email address on here, and I'm happy to answer questions and talk to anyone also. So, Dina, I keep it really short so that there would be time for questions from anyone.
You did awesome. That was great information, Kathy. I've unmuted so we can hear some of that background noise. If y'all could mute, I'm going to turn it over to
I'm going to stop sharing my
Kenya.
screen.
Oh, I'm going to put myself as the presenter again. And Kenya, if you want to do wrap up, or we can take some questions, and then I can mute all if needed.
Okay. We definitely want to give an opportunity to take questions, but let me just touch on a few things before we make sure we have Well, so why don't you go ahead and do the questions now, and then I'll wrap up probably about 5 minutes too.
Okay. Questions for one of the speakers? I have everybody unmuted, so if you just mute your individual self until you're ready to speak, we'll all be able to hear okay. Questions for Kathy or Kerry on the information they covered, or me on the FEMA process? And like I said, I'm happy to take emails or phone calls. I know we're dealing with 2 different disasters right now. COVID, that we're all dealing with, and then with y'all's tornado and everything. But we are ready to help and assist any way we can. So
I have a question that's not related to either one, really. I'm also dealing with reentry people, and I'm wondering if on housing issues, are there any one of those housing resources that would be useful for people who have felony convictions?
Just to try to say that we do handle some reentry work through legal aid. And so to the extent that someone does have convictions that are making it challenging for them to get into housing, send them our way. We'll be happy to do what we can to try and remove those barriers.
And
Great.
this is Kathy, and HUD has come out with regulations and with saying that if a complex or a landlord has a blanket denial of anyone who has a felony, that might per se be illegal, might violate the Fair Housing Act. And also there have been times when the what I did was related to a disability. In other words, a recurring addict or alcoholic, if they did the crime years ago, they've paid their time and it was due to their use, illegal drug use, or alcohol, for to help remove barriers.
Okay, great. Thank you.
Any questions for one of the speakers? All right, Kenya, if we don't have any other questions, like I said, I'm happy to answer anything by phone or email if you want to take over.
Okay. Once again, thanks to everyone for your patience through the process, and using your phones as requested from time to time. Make sure that we are able to communicate this very important information. Just want to remind everyone that there are encourage you to visit the Legal Aid Society website at las.org in order to access our Tornado Resource Center. That includes, again, a lot of resources around tornado recovery. First, you'll find on our Tornado Resource page is to the legal clinics that Legal Aid has available where attorneys can volunteer to assist options who are needing help with tornado recovery. We continue to update that legal clinic page as new clinics are being added, as well as clinics are being deleted. There are some facilities as a response to the COVID-19 pandemic that are in fact closing facilities, and we are making efforts to accommodate those and look for alternate delivery service methods to ensure that people are getting the information that they need. One of those alternate sources is the Tennessee Alliance for Legal Services hotline, that it has become the hotline for the for Tennessee relevant to tornado recovery. You can access that phone number and give it to anyone who's needing legal advice. That number is simply 844-HELP, the number 4TN. 844-HELP for Tennessee or 844-HELP for TN. Once you get that line, someone will greet you and will then be to set an appointment for you to meet with an attorney phone in order to get legal advice. So that is certainly something that you share with those who you may come in contact with at legal clinics or otherwise seeking free legal advice around their circumstances. There's also freelegalanswers.org, and you can find that at tin.freelegalanswers.org. And this is actually an online service. Persons can enter in questions online that will then be responded to by volunteer attorneys. That's tin.freelegalanswers.org, and it's a site or email listing from the Tennessee Alliance for Legal Services, who is a partner for this event today. If you're interested in volunteering for that Tennessee Free Legal Answers or volunteering at any of the legal clinics you may find at las.org, you can go to the TBA website. The Tennessee Bar Association is also a partner for this program today. The Tennessee Bar Association has a sign-up sheet that is where information is then transmitted to Legal Aid Society as well as the Tennessee Alliance for Legal Services. Begin to sign attorneys up to assist at legal clinics and to assist with Tennessee Free Legal Answers. You can access that at www.tba.org/tornado_volunteers. t.org/tornado_volunteers. In that, at the conclusion of this program, we will be posting the recorded program today to the NBA National Bar Association website and YouTube pages, as well as to the Legal Aid Society website and YouTube page in our resource area. So if you'd like to access this recording at a later time, please go to the National Bar Association YouTube page or the Legal Aid Society YouTube page to access it there. At this time, the recording today, unfortunately, is not available for CLE credit. As you all know, that this program was initially scheduled to be an in-person session due to recent developments with the COVID-19 pandemic. It switched to an online platform to ensure that we could have the most impact for the most attorneys who wanted to have this valuable information and be able to use it for those people who need our services. I want to thank everyone for your attendance today, and especially for our sponsors. Again, the National Bar Association, the Tennessee Bar Association, Legal Society of Middle Tennessee and the Cumberlands, as well as the Tennessee Alliance for Legal Services. Thank you all so much for joining us. Please continue to check the various opportunities to volunteer so that you can be of assistance to those people who need you the most. If there's nothing further or no further questions, I want to thank you all for attending. Have a great day.